Here at the firm, we do not only trial practice, but if a case is appealed by the railroad, as sometimes happens, then we have to do what's called appellate practice. I have one of the best appellate practice lawyers working with me who used to work for the Court of Appeals here in Minnesota. His name's Chris Bowman, but I've actually done some appellate practice myself. I prefer to have someone else work on it also, but I was asked twice to assist various organizations in railroad cases in appellate practice. I've done some of my own appeals in the past and argued in both the Minnesota Supreme Court, the U.S. Court of Appeals, and for the 8th Circuit, the 9th Circuit. And I've had two cases, actually three cases, that I've had to have briefs written for the U.S. Supreme Court. One was one of my cases I tried many years ago, and I did the briefing on that. And then more recently, in a case called Norfolk and Western Railway versus Freeman Ayers, the Brotherhood of Locomotive Engineers and Trainment asked me to write a brief, or our firm to write a brief for them in the Supreme Court on that case. It wasn't our case, but we wanted to make sure the Supreme Court did it right. And I could show you, this is a copy of the brief that we wrote, and if you look on it, this is called an amicus brief. You'll see my name on there. I was the admitted lawyer that filed the brief, and our firm did this for free of charge for the railroad, or for the union. And we also did one for more recently in the case of CSX Transportation versus Robert McBride. And this was a case where ARLA, the lawyers organization that does that represents railroad lawyers, asked me to again write an amicus brief for them, and myself and people in our firm put that together. And both of those cases, the Supreme Court ruled our way, and so they're big victories for railroad workers. So that's the ultimate in appellate practice. But if you win a trial, the odds are they will at least appeal back to the trial court, and we're well versed to do it. We've got every brief we've ever done. As a matter of fact, I'm the author of 4 books on railroad law, 4 different editions of the railroad law, kind of the Bible, which I could show you. But we keep up with the law. We really do, and we have to, and lawyers should keep up with it. And that's another reason. With our firm's 90 years of experience, my 40 years plus, and all the experience in the firm, I can't think of a firm that's better equipped to represent people, either in their case for trial or on appeal.